Thank you and good morning. Fantastic to have the chance to be here again in EFTA. Well, the first time actually in EFTA House, but again in front of people on the ES seminar. So very happy to be here and talk about how EU law becomes EEA law. And as has already been kind of mentioned, this is not something that happens automatically. The fact is that every year the EEA Joint Committee takes hundreds of decisions incorporating new EU legal acts and making part of the EEA agreement. And that, of course, requires a very efficient, clear, transparent, and effective procedures to manage to do that, because every single decision of the EEA Joint Committee is in fact amending the agreement and can be considered as an international agreement in itself. So we have actually quite a lot of very useful information about this on our website. We have a web tool that explains this in some detail, and we have also a video that is very informative, and those that are interested, I would very much encourage you to look into this. We have divided this process into basically 8 stages, and I will go through all of these 8 stages here, some of them quite quickly, starting from the first stage when the EU starts to prepare a proposal for new legislations, and ending in a period when this legislation has been adopted by the EU, been made part of the EU agreement, and has been fully implemented by the EFTA states. So first, on the decision shaping, I believe that this has already been discussed here today, so I'm not going to go into very much detail into that, but I will highlight some point. The EU agreement establishes that the experts from the EFTA states have the right to participate in the shaping of new EU legislation. This is particularly enshrined in Articles 99 and Articles 100 of the EU agreement that allow the EFTA states to provide their views when new EU legislation is being formulated. Once a proposal has been formally submitted, it goes to the decision-making process within the EU, and there the EFTA states are not participants, and I'm not going to go into detail. That's a whole other study of how the legislative process works on the EU side. But the final stage in that process is that a new legislation is published in the official journal of the European Union. And often you will see when new legislation is published that it is marked as a text of with EEA relevance. This in itself has no legal effect, but it's an indication of the EU's view that the legislation in question falls under the scope of the EEA agreement. At this point, when the EU has adopted new legislation, the incorporation process can start. And the first start is identification and a preliminary assessment by the EFTA Secretariat. And the EFTA Secretariat screens all new EU legislation and identifies acts that may be relevant to the agreement. That is, acts that fall onto the scope of the agreement. And as we have kind of discussed, the internal market is very at the heart of the EEA agreement. And when we talk about EEA relevance, we are mostly referring to legislation that relates to the internal market. Of course, the EU has a few other policy areas, such as the common commercial policy, customs union, etc. And those fall outside of the scope of the agreement are not, and legislation in those fields are not incorporated. But legislation that falls under the internal market is usually EEA relevant that would be incorporated. So what the Secretariat does is to screen all new legislation and conducts a preliminary assessment. And there are basically 2 essential questions that the Secretariat looks into. Is this legislation that is EEA relevant? And if that is the case, are there adaptations needed this act would be incorporated. And essentially every EU legislation, because it's adopted by the EU institutions and applied to the EU member states, needs adaptations. But that doesn't mean that such an adaptation needs to be made in every single case. That may sound like a paradox, but I will explain why a little bit later. Once this assessment is made, the new legal act is sent to the experts of the EFTA state, either members of the working or expert groups, for the assessment. And at this point, the Secretariat make an assessment on what kind of a procedure will be followed when in preparation of incorporating that act. And we make a distinction particularly between so-called fast track or standard procedure. The fast track obviously is supposed to be faster, and it's actually the procedure that is used more often, but it's also more simplified. But in the case of standard procedure, there is longer time that is given to our experts in assessing acts. When we are sending the acts, we do send out with different forms, but depending on which procedure is followed. I'm not going to go very much into the detail of these forms, but I will highlight that that even if the Secretariat proposed that a fast track is established or used, any of our member state can object to that, and then we will follow the standard procedure, and that provides for a longer assessment. So once the Secretariat had sent out these forms, then it's up to the experts in our member states to assess the acts. And again, the main questions that they need to assess are the two main issues that I referred to earlier. Is the act EEA relevant? And is there a need for adaptations? And when we talk about adaptations, we do kind of make two distinctions. First is the form of the adaptations, and we distinguish between three forms of adaptations: the so-called horizontal adaptations, sectoral adaptations, or specific adaptations. And as I mentioned, every single act really needs to be adapted, but the adaptation doesn't need to be done in every single case, because there are provisions in the agreement contained in, first of all, Protocol 1 of the agreement, and secondly, in some annexes of the agreement that caters to most of the adaptations that are necessary. So they are already actually are actually kind of part and parcel of the agreement. They don't have to be made in every single case. And a very common example of that is that any reference to EU member states or nationals of EU member states in EU legislation is actually covered by Protocol 1, the horizontal adaptations, and should be read in the context of the EU agreement as either a reference to the contracting parties of the agreement, meaning either the EFTA states or an EU member states, or the nationals of the contracting parties, meaning nationals of both the EFTA states and the EU member states. But if there is something in a legal act that actually requires adaptations that is not covered by either the horizontal or sectoral one, then we talk about so-called specific adaptations, and those are included in every single JCT that or the JCT that incorporates this specific act. But regardless of this, the effect of all of these adaptations is the same. When a legal act that has been incorporated into the agreement is read, it has to be read with the view of these adaptations. The other distinction that we made when we talk about adaptations is between technical adaptations and substantive adaptations. I will not go very much into the detail of this distinction, but I would just highlight that this relates to the procedures on the EU side, If there are substantive adaptations, that means that the EU Council needs to agree to such adaptations, but the Commission has a mandate to agree to so-called technical adaptations. So it can have a consequence for the length of the incorporation procedure, whether adaptations are technical or substantive. Now, all of our member states have their own national procedures on how to make the determination on these two essential questions, EEA relevance and whether there's a need for adaptations. And we have some information on those procedures in our web tool that I referred to earlier. Once we have gotten the feedback from the member states, we can actually start the work on drafting the decision to incorporate an act. And this is done by the EFTA Secretariat based on the feedback that we received. Then when the drafting is done, it is submitted to the EFTA states, both in the so-called working groups, and then in the so-called subcommittees, which are subcommittees to the EFTA Standing Committee. And once it has been approved there, it is submitted formally to the European Commission, to the General Secretariat, that on that basis can launch the so-called inter-services consultation, which is the basis for the EU approval of the draft. Now, at this point, we can go to the sixth step of this incorporation process, which is the review by the EU. As I mentioned, once we have submitted to the draft JCT, it goes through inter-services consultation, where the relevant Director General and the Commission Legal Services assess the draft JCT and whether the services can agree to it, and whether they also have to assess whether there are any substantive adaptations that will require Council approval. And in that case, the draft JCT also has to go through the Council approval procedure. Now, once there is an approval by both parties, both the EU, both the EFTA side and the EU side on the draft JCT, it is ready to be incorporated into the agreement. And that is, sorry, I should go to the next slide, as I already covered this. Yeah, once there is an agreement, it is the actual decision to incorporate can be done. And as I mentioned, the Joint Committee takes hundreds of decisions every year. And of course, you have to have some kind of a system on how to prepare a decision for adaptation. We do that by a procedure that we call the so-called long list procedure. And basically what we do is that the Secretariat gathers a list of all JCTs that have undergone this approval procedure that I have explained, and then sends that list of decisions that are ready for adoption to the General Secretariat, that assesses it, sees if they have concluded their own procedure, and if that is the case, there is an agreement between both sides on the list of acts, list of the JCTs, draft Joint Committee decision that can be put on the agenda of the next EEA Joint Committee meeting. And the Joint Committee meets 6 to 8 times every year to adopt the decisions. Now, the EEA Joint Committee takes all decisions by consensus, so there has to be an agreement by both the EFTA side and the EU side in order for to take any decision incorporating new EU legislation. Once a decision has been adopted, it will, in most cases, enter into force the day after. But there are some exceptions to that, and the most important one is if any of the EFTA states makes what is called a constitutional requirement to a decision. And according to the agreement, the EFTA states have the right to make this constitutional requirement when a decision is adopted. And that means that it shall not enter into force until the country in question has notified that it has fulfilled these constitutional requirements. Essentially, this means that this will have to go through parliamentary procedure. In the EFTA states, they have to, the member states have to get approval for parliament to incorporate these acts into the agreement. It is, according to the agreement, the states have 6 months to fulfill that, and if they need to go beyond the 6 months, they do need to notify the Joint Committee of this delay. Now, this is an example of a decision of the EEA Joint Committee, and usually has 3 main elements. First, amending the annexes, or in some cases protocols of the agreement, by including a reference to the acts that are being incorporated. Secondly, provision on publication, both of publication in Norwegian and Icelandic of the legal act that's being incorporated, but also a publication of the decision itself, and then finally enter into force. But if there are adaptations, specific adaptations that need to be made, that will also be included in the decision. Now, this is not the final stage. The adaptation by the Joint Committee and fulfillment of the Constitution, not the final stage, because all of this has to be taken. The EFTA states have to make sure that they have incorporated the acts into their own national legal order. That is, that they made them effective in their own national legislation. And this, of course, may require amendments to their legislation. And it is the role of the EFTA Surveillance Authority to monitor that the EFTA states are doing so. And any disputes on that matter can go to the EFTA court. But you will hear presentations from both institutions in the afternoon. So that is essentially these 8 stages of incorporation that we have outlined, and are, like I said, discussed in more detail in the web tool that those that are interested can consult. Thank you.